Well, welcome to this Bond Solon video for expert witnesses. You've probably read that the Civil Justice Council has published the guidance for the instruction of experts to give evidence in civil claims 2012. The stated purpose of this guidance is to assist litigants, those instructing experts and experts in understanding latest is best practice with regard to compliance with Part 35 of the Civil Procedure Rules and its overriding objective. It replaces the current protocol. The rewrite was undertaken by a working party chaired by our distinguished guest John Pickering. Well, welcome, John. Perhaps you could just tell us a little bit about yourself.
Well, I'm the Chief Executive of Irwin Mitchell Solicitors. I'm a litigator by background, specialising in personal injury and clinical negligence cases. And as you know, I sit on the Civil Justice Council.
So you must have worked with many experts in your time.
A lot in the years, yes.
Why did the council decide to revise the guidance and bring out this new guidance?
The old protocol was just that. It was getting a bit old, and it was felt that it needed bringing up to date. We needed just to check that it was relevant in terms of current case law, and it needed a refresh.
Right. And what would you say were the main changes of this?
They're not huge, but what we've tried to do is make it much more user-friendly. So you'll see that the format of the guidance is such that it's aimed at those who are instructing experts, predominantly solicitors obviously, but also then at experts, what's their perspective, how should they engage in this area. And then there are some general points which sweep up at the end. So it's a bit more focused in terms of how it's organised.
Well, I must say it seems much easier to read than the last documentation, and I would encourage our experts to read it themselves. It encourages a lot more careful instruction of experts, I would say. Can you perhaps tell us what the guidance is on the appointment of experts?
Yes, much of it is common sense, to be perfectly honest. Clearly, the starting point is to make sure that you identify the right expert. So someone who has got the requisite expertise and experience to assist you with the particular issue. And then thereafter, it's just making sure that you can agree suitable terms, that they're available for you, that they can report within your timeframes, and that they can make themselves available, if required, to attend court.
I noticed you missed the word fees there, and that's also a very hot topic for experts. I think there are some powers now to limit the fees and to get estimates of fees. Do you want to expand a little on that?
Well, I think the starting point is that the question of fees is really still a matter of contract as between expert and those instructing the expert. But of course the issues become what is recoverable. In most of the litigation that we deal with, particularly personal injury, then there are limits that are going to be imposed by the courts, by legal aid people and so on, as to the fees that can be recovered inter partes for experts. And in turn, those instructing experts are mindful of them and effectively don't want to be in a position where an expert is charging more than those sorts of guidelines.
Sure. And I suppose this complies with the Jackson reforms, makes more compliant with that.
Yes, it does. That's right.
Now, experts often report that they have to amend their reports. Do you have any comments on that?
Yeah, that is frequently the case. In many situations, particularly the more complicated cases, say clinical negligence cases, things can evolve. New evidence can emerge, new witness material might be presented. Therefore, it becomes necessary for an expert to revisit their opinion and, if appropriate, make amendments. And the question is therefore one of scale. Is it a minor amendment, which might just be a quick note and not requiring of something that demands a substantial rewrite of the report, or is it something more fundamental than that? I suppose the end point is to make sure that there is produced a document which at the end of the day is going to meet the Part 35 requirement and be useful in court.
Sure. It seems the whole thrust of the rules is trying to narrow the issues between experts, and obviously discussions play a major part in that. Are there any changes regarding discussions in these new
No, there was nothing that's changed vis-a-vis discussions, but what we have tried to do is to make sure that people really just do apply their minds to what is involved in experts' meetings. And so there is guidance there about preparation, about how the meeting should be conducted, the desirability of producing a note early after the meeting has taken place, and so on. As you rightly say, the purpose of the meeting is really to see the extent to which issues can be narrowed, therefore the extent to which there is agreement on particular issues, and also where the areas of disagreement might be.
Sure.
So that come the case going to court, the court has a clear understanding of where the real territory is that needs to be explored.
And I think there's also some guidance about solicitors trying to stop experts actually coming to some sort of agreement, and that has to be explicit in the report. Is that correct?
It does, that's right. The idea is essentially that solicitors should not interfere with the process.
Sure.
And clearly there might be times when, say, a solicitor is in a meeting and the experts might require guidance on a particular point of law. Well, fair enough. But what a solicitor shouldn't really seek to do is to intervene with the expert's process of expressing an objective professional opinion. And so there are gradations, therefore, that come into play in at that point.
And perhaps you'd be kind enough to explain the difference between experts instructed prior to the commencement of litigation and those instructed after the commencement of litigation, and the guidance there.
The guidance is essentially aimed at those experts that have been instructed for the purposes of litigation.
Sure.
And by that, I mean those who are potentially instructed when the court has made an order permitting the instruction of experts, or indeed the court has specifically asked for an expert's report. So the guidance is aimed at those experts that are really going to be engaged in the litigation process and may ultimately have to appear in court.
Sure.
However, it is the case that there are a number of situations where solicitors might literally just go to an expert to seek preliminary advice,
Sure.
not intending then to instruct that expert subsequently in the context of any court litigation. In that case, that's the expert the expert acting in a purely advisory capacity, but the implications of Part 35 are not really present.
No.
In the former area, which is what guidance is aimed at, then all the Part 35 obligations are very much to the fore.
Well, we've all heard about Jones and Caney and liability and contract and negligence for expert witnesses. How has that impacted your thinking in the committee in terms of this guidance?
Well, the Jones and Caney case, we effectively sought to remove the indemnity that existed, or the protection, the immunity that existed for experts giving evidence in court. So there is the potential risk of an expert being found to be negligent in terms of the way they give their evidence in court. So that is opened up now. And therefore the guidance was really trying to get experts properly to think about what their obligations are, to deliver an objective opinion. And if they follow the guidance and behave in that way, then they should mitigate completely the risk of being negligent and being at risk.
Sure. Asking for directions, this was allowed under the original rules. Is there any change in that?
No, what the guidance has not done is in any way change the rules.
No.
So the rules, i.e. Part 35 and the practice direction, they have not been altered. But what the guidance is trying to do is to put that in a current context. So in terms of experts being able to go to the court to ask a judge, say, for guidance, that is still permissible. That can happen. Clearly, one needs to be sensible about how that might operate. The first port of call for an expert is their own solicitor.
Sure.
And if the solicitor resolves it, then so be it. It's only in the last resort where an expert really is in difficulty. They have the ability to be able to go to a court and say, I need some help here, maybe to get access to evidence or whatever.
Sure. The cornerstone of much of the experts' work is obviously the report. Is there any further guidance on report writing?
The writing of the report, no. The content of the report is set out in the guidance, but the fundamentals are still there. And I suppose that is a hark back to the older Carey and Reefer principles, making sure that one's being properly briefed, that the nature of the instructions are clear, and that one is then applying a proper objective standard to the preparation of an opinion, utilising the relevant material and also the latest thinking in terms of, medical advancements or whatever it may be.
I think there is now a duty on the expert to ensure the clarity of instructions, so I think it is important the experts do read this guidance, isn't it?
Very much so. If one is going to engage in this arena, then that's a very serious point.
Sure.
It's a serious point for the expert in terms of their professional integrity and how they want to be perceived operating in that space. It's crucially important for the client whose solicitor is instructing them. So this is not an area to be taken lightly, and therefore the more that an expert can do to engage and really understand what their remit is, the better.
And of course they now have to state in their report that they do understand the rules.
Absolutely right.
Going back to the exciting subject of fees and contingency fees, Jackson's obviously saying that much civil litigation can be done on a contingency fee basis. I think the guidance says only in exceptional cases can experts work in that way. Do you have any thoughts on that?
Yes, this is the reason that is there is because of a Court of Appeal authority which essentially countenance the potential for a situation to arise when an expert might be instructed on a contingent basis. The simple legal point is that there is no actual bar to an expert being instructed on a contingent basis. However, the strong view expressed by the working party that I was involved with and subsequently by the council was that was a set of circumstances that we found difficult to envisage because self-evidently the expert that is working on a contingent basis has a vested interest in the outcome of the case. And that's felt to be a rather undesirable position when essentially the function of the expert is there to give objective evidence and not to be partisan as such.
But there is a chink in the door.
There's a chink in the door. I struggle to conceive of the case where that is likely to happen, or indeed where the expert, his or herself, would feel comfortable
working on that basis.
On that basis, they would be exposed to potentially quite intense cross-examination.
Single joint experts, anything new for them?
I think the new thing in this area is the sheer prevalence of the use of single joint experts, particularly in small claims, particularly in fast track. And of course one now has the growth of the size of the fast track. One also has the development of the portal for the Ministry of Justice portal in road traffic accident cases, and the potential for that to extend into employers' liability and public liability. So I think it's not so much the rules of engagement for single joint experts. It's more about this becoming a much more common feature of the legal landscape.
Sure. Sanctions. Should this worry experts?
We put in a bit about sanctions because the previous protocol and indeed other areas have been relatively silent about sanctions. Sanctions exist
already,
and they are there, and they can take broadly two forms. The expert could be sanctioned by their own professional body if they misbehave, but also they could be sanctioned by a court in extremis. So the expert that gives or commits perjury, for example, could potentially face criminal sanction. Some of this is extreme, but the ability to sanction in costs exists.
It's just a matter of interest. Do you think the professional bodies are ready up with what's going on? Do you think they need to know that experts are potentially in the frame here?
I think all the professional bodies ought to be aware of this guidance and ought to make sure that their members that contemplate giving expert evidence are briefed about that. I don't think that experts should be deterred by the fact that there is the potential for sanction. We put it in the guidance really just to complete the picture
Sure.
and just to make sure that people take this very seriously. We haven't put it in to deter people at all.
So, is this the end of the amateur expert? Have experts now got to be professional, know their law and procedure, know their protocols, etc.?
That's a very good question. I don't think one is looking for the expert to be effectively two experts, i.e.
Sure.
in their own expertise and a lawyer as well.
Sure.
That's not where we're going. But what we are saying is, think about this seriously. You are engaging in a very serious area. This is something where you need to be very mindful of your professional obligations and apply professional standards. If you do that, then you'll negotiate that safely, comfortably, even if you are a first-time expert, unfamiliar with the scene.
And any further thoughts for our experts?
Well, from a practitioner with a lot of experience in, say, the clinical negligence field, I would encourage experts to engage for two reasons, actually. The first is that there is a need for good experts, competent professionals, to express opinions in many cases. And actually, in a number of areas, it is difficult to get hold of people who will give opinions. So there is a shortage in some areas. But the second reason is, from the expert's point of view, and many experts have said this to me, it is a good discipline. It makes you apply your own mind to your practice. It makes you think about what you're doing and how you work in your own environment, and that's a healthy thing.
Well, John, thank you very much. Thank you very much. Thank you.
You're welcome.